Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope today is the day I earn that subscription. For today's coverage, we are going to be looking at 3 U.S. Supreme Court decisions that were just decided this morning and trying to understand that. Of course, the big one that a lot of people were looking at, including myself, Students for Fair Admission versus Harvard versus UNC, a case dealing with race-based preferences at colleges, one of the ones I was really following very intensely. We also have a case dealing with religious accommodation as it relates to a postal worker doesn't want to work Sundays because of his religious beliefs. And the question is, what kind of accommodation does the Postal Service, or for that matter, any employer, have to give when it comes to religious accommodation? And also one dealing with the Lanham Act, which deals with trademark law and the applicability of U.S. trademark law outside the borders of the United States. So, does the United States law apply outside the borders of the U.S. law? Great. We'll be doing all those things. Let's go ahead and get started right away. For today's story, we look at one of the big ones this term, dealing with race-based preferences at colleges. Many colleges have a race-based preference and give points or other advantage to people of particular race or racial backgrounds. Of course, by necessity, giving someone an advantage necessarily puts someone else at a disadvantage, because to add points to someone is exactly the same mathematically as subtracting those points from someone else. You can't advantage someone without disadvantaging someone. So, should we advantage certain races on the basis of race? Well, if we do that, we have race based preferences and we're discriminating also on the basis of race. So, that's a problem. But this has been legal up until now, and now is being challenged in this case. Students for Fair Admission versus Harvard versus UNC. One, of course, is a private college. One, of course, is a state college. So this court could, of course, split the difference there if it wanted to, because only the state is applicable to the Constitution. But there is a statute in place, the Civil Rights Act, that says there shouldn't be discrimination on the basis of race. So if we decide this on purely constitutional grounds, we might split the difference. If we decide this on statutory grounds, we might not. Let's go ahead and see what's going on with this. Marie, I have no particular thoughts on the Peterson verdict going into day 3 of deliberations. The jury will do whatever it does. It takes as long as it takes. I'm sure they're thinking about a lot of things. But thank you for the super chat. Harvard College, which is the oldest college in the United States, and the University of North Carolina are two of the oldest institutions of higher learning in the United States. Well, Harvard College is literally the oldest, I believe. And so, yeah, that's part of their tradition. Every year, tens of thousands of students apply to each school. Many fewer are admitted. Both Harvard and UNC employ a highly selective admission process to make their decisions. Admissions to each school can depend on student grades, recommendation letters, or extracurricular involvement. It can also depend on race. The question presented is whether the admission systems used by Harvard College and the University of North Carolina are lawful under the Equal Protection Clause of the 14th Amendment. At Harvard, each application for admission is initially screened by a first reader who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. For the overall category, a composite of 5 other ratings, a first reader can and does consider applicants' race. Harvard's administration subcommittees then review all applications from a particular geographic area. These regional subcommittees make recommendations to the full admissions committee and then take an applicant's race into account. When the 40-member full admission committee begins its deliberations, it discusses the relative breakdown of applicants by race. The goal of the process, according to Harvard's director of admission, is ensuring that there's no dramatic drop-off in minority applications from the prior class. An applicant receiving a majority of the full committee votes is tentatively accepted for admission. At the end of the process, the racial composition of the tentative applicant pool is disclosed to the committee. The last stage of applicants' process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial age eligibility, and race. In Harvard's admission process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Okay, so what we've got here from the idea of Harvard is we're considering race basically every step of the way. We consider it as part of their initial rating. So there is a guy who does an initial rating for each applicant who, as part of that, considers race. And then their recommendations get bumped up to a regional committee, which considers race. And then their recommendations get bumped up to a 40-member final determining committee, which then determines whether or not to admit people by a majority vote. They wind up with more people than they can support. And then they have to figure out how to winnow down the people that receive majority support to the actual admission list. And at that point, they also consider race explicitly. So at every step of the way, race provides an advantage, a discriminatory factor. Okay. UNC has a separate admissions process. Apologies. UNC has a similar admissions process. Every application is reviewed first by admission officer reader, who assigns a numerical rating to each of several categories. Readers are required to consider the applicant's race as a factor in review. Readers then make a written recommendation on each assigned application, and they may provide an applicant a substantial plus depending on an applicant's race. At this stage, most recommendations are provisionally final. A committee of experienced staff members then reviews a school group review of each individual decision made by a reader and either approves or rejects the recommendation. In making those decisions, the committee may consider race. So UNC does a simpler process. They have a guy who looks at it and makes a determination, yes or no. That guy's decision is presumptively correct. And in reviewing it, in terms of its correctness, the admissions committee also considers race. All right, petitioner. For Students for Fair Admission is a nonprofit organization whose stated purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under law. The SFFA filed separate lawsuits against Harvard and UNC, arguing the race-based admissions violate, respectively, Title VI of the Civil Rights Act, because that would apply to a private school, and the Equal Protection Clause of the 14th Amendment, which would apply to the government school. After separate bench trials, both admissions programs were found to be permissible under the relative precedent, which would be correct for the lower courts. That would be the correct decision given the precedent, because only the Supreme Court can change the precedent. So the lower courts were kind of bounded here. In the Harvard case, the First Circuit affirmed, and this court grants certiorari. In the UNC case, this court grants certiorari before judgment. So they yanked it out of order, right? Having seen that the First Circuit case was asked for review, they decided to also take along UNC for the ride. So it had been appealed to the Court of Appeals, but they decided to yank it out of order, which of course the Supreme Court can do because it's a higher court of review. Okay, with that background, what is the relative law? Held, Harvard and UNC's admissions programs violate equal protection clause of the 14th Amendment. Okay, that's kind of interesting. We want to say that Harvard is violating the equal protection clause of the 14th Amendment. All right, that's interesting because Harvard is a private institution. So the immediate thought I have is, how can Harvard violate the equal protection clause? Is it because they accept governmental money and that means that they're bound by the equal protection clause? What is their tie to the equal protection clause? If they said that Harvard is bound by the statute, then I would understand. But they say that Harvard is bound by the Constitution. Why? Let's read more. Because the Students for Fair Admission complies with standing requirement for organizational plaintiffs, the SFFA's obligation under Article 3 are satisfied and the court has jurisdiction. Yeah, we don't really have time to really delve into the depths of when an organization has standing to bring claims on behalf of its members. The court's going to talk about it a little bit now, but it's a little bit more complicated than the court's about to let on. So we don't really have time to get into it, but they say that yes, they're standing. The court rejects UNC's argument that the organization lacks standing because it's not a genuine membership organization. An organizational plaintiff can satisfy standing in one of two ways, one of which is to assert standing solely as a representative of its members, an approach known as representative or organizational standing. To invoke it, an organization must satisfy a three-part test. Respondents do not suggest that the organization fails the test for organizational standing. They argue instead the organization cannot invoke organizational standing at all because it's not a genuine membership organization at the time it filed suit. So, yes, they meet the tests, but they're really a fraud, is the idea. They superficially meet the test you've laid out, but it's not really a membership organization. They're just pretending to be one. Okie dokie. The respondents maintain that under the relevant law, a group qualifies as a genuine membership organization only if it's controlled and funded by its members. In a relevant case, this court determined that a state agency with no traditional members could still qualify as a genuine membership organization in substance because the agency represented the interests of individuals and otherwise satisfied the three-part test for organizational standing. So, yes, there might be a state level agency that represents a group of people. For example, the thing that would come most notably to mind might be in relation to alcoholic beverages, because obviously that's a regulated trade. And so those organizations, even if they're state created, might represent its members and might have an interest in its members, who may be compelled to be members, but still might have an interest to raise the interest of its own members. So the fact that it's not controlled by the members because it's a state agency is not a problem, apparently. The indicia of membership analysis in the prior case law has no applicability here. As the court found below, the SFFA is indisputably a voluntary membership organization with identifiable members who support its mission and whom they represent in good faith. They're thus entitled to organizational standing. So, first of all, membership control is not necessarily required. Second of all, it's not relevant here because this really is a membership organization, not a fraud. So, fine. And also, that would be presumably a question of fact. Thank you for the 10 Canadian dollars. Yeah, whether SFFA is really a membership organization or whether it's a fraud is underlyingly a question of fact. So it's not surprising that the Supreme Court, of course, defers to the lower court on that because it's a factual based question. So fine. Proposed by Congress and ratified by the states in the wake of the Civil War, the 14th Amendment provides that no state shall deny any person the equal protection of the law. Proponents of the Equal Protection Clause describe its foundational principle as not permitting any distinctions of law based on race or color. Any law which operates on one man, they maintained, should operate equally on all. Accordingly, as this court's early decisions interpreting the Equal Protection Clause explain, the 14th Amendment guaranteed that the law in the states shall be the same for black as white, that all persons, whether colored or white, shall stand equal before the laws of the states. Despite the early recognition of the broad sweep of the Equal Protection Clause, this court, along with the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing Plessy versus Ferguson, the separate but equal regime that would come to deface much of America. So the Supreme Court throwing a little shade on itself, and well earned shade at that, because yeah, the Supreme Court, along with states, along with a lot of other things, did not really give full faith to the Equal Protection Clause for quite some time when it came to state-based action. After Plessy, American courts labored with the doctrine of separate but equal for a half century. Yeah, that mistake lasted a while, guys. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing it required states to provide black students educational opportunities equal to, if even formally separate from, those enjoyed by white students. So, yeah, perhaps somewhat unsurprisingly, after Plessy, people didn't really like it so much. And so they tried to like whittle down at it without overruling it explicitly because the Supreme Court doesn't like to really admit it makes mistakes. So they try to like create these exceptions and create these carve outs. And then you eventually wind up at a place where the underlying doctrine is so carved out and so broken that there's nothing left. You basically carved out everything. And yeah, that's kind of what happens. So eventually you have to admit that you made a mistake because you've carved out everything. So there's nothing left. Yeah. But the inherent folly of that approach of trying to deprive equality, of trying to derive equality from inequality soon became apparent. As this court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate affected students. By 1950, the inevitable truth of the 14th Amendment had thus begun to reemerge. Separate cannot be equal. Yeah, there were definitely some mistakes made along the way when it came to the interpretation of, racism is bad. And it's like, how about some racism? How about separate but equal? Is that okay, racism? Yeah. The culmination of this approach finally came in Brown versus Board. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure, which is to say, by law, racial discrimination by the states and federal government. This court reached the conclusion in Brown that was unmistakably clear. The right to public education must be available to all on equal terms. The court reiterated the rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non-discriminatory basis. Yeah, we figured that out a long time ago in Brown, and apparently still having the problem. Some schools still have apparently not gotten the memo. In the years that followed, Brown's fundamental principle that racial discrimination in public education is unconstitutional reached other areas of life. For example, state and local laws requiring segregation in busing, racial segregation in the enjoyment of public beaches and bathhouses, and anti-miscegenation laws, which is where you can't marry someone of a different race. These decisions, along others like them, reflect a core purpose of the Equal Protection Clause, doing away with all government imposed discrimination on the basis of race. That does seem to be what the 14th Amendment says. I mean, it says equal protection of the law. And if the 14th Amendment wasn't enough clue, there's also the 13th and 15th Amendments, which also speak about race very explicitly. So, probably should treat the races the same if we look at the Constitution. That's kind of what they had in mind. Okay. Eliminating racial discrimination means eliminating all of it. Sounds good to me. Accordingly, this court has held equal protection clause applies without regard to any difference of race, color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to another person of color. Yeah, because if equal protection meant something different based on color, how equal is it? Yeah. Any exceptions to the Equal Protection Clause guarantee must survive a daunting two-step examination known as strict scrutiny. That's what it's supposed to do, yes, which asks first whether the racial classification is used to further a compelling governmental interest. The word compelling here is carrying a lot of weight, by the way, because when we think about the three major standards, and there are little substandards, depending on which case you're reading, but for the three major categories, there are three ways the government can act, right? It can act normally, it acts in sort of intermediate scrutiny or strict scrutiny. Intermediate scrutiny we typically do for example, sex-based discrimination. All right, so if we want to go through the relevant standards, we move from a legitimate governmental interest to an important governmental interest to a compelling governmental interest. So the word compelling here is doing a lot of heavy lifting. And what we mean by compelling is compelling, right? Not just legitimate, not just importance, compelling, urgent, required. That kind of thing is what we're looking for. And second, whether the government's use is narrowly tailored. That is necessary. So is it basically the least you can possibly do? because we think that this kind of discrimination is really, really bad. So, in order for you to discriminate in this kind of way, your interest has to be really, 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 really important. And it also has to be as small as it can possibly be, right? You have to solve the problem and no more, no broad solutions. This has to be a very pinpoint, nuanced solution in order to deal with the problem so as to not to undermine the rule. So that's the only way we'll allow this. Admissions of race based state action is rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odorous to a free people whose institutions are founded on the doctrine of equality. Yeah, strict scrutiny is supposed to be really, really hard. Strict scrutiny has been called strict in theory and fatal in practice because you're not supposed to be able to make strict scrutiny. It's supposed to be really hard. So yeah, it basically should basically never work. And the exceptions are truly the exceptions. And only for the most compelling reasons and only in the most narrow cases. Right? So are you getting the idea? Yeah. The court first considered whether a university may race-based discrimination in Bakke in a deeply splintered decision that produced 6 different opinions, which is always such a joy for all of us working in Supreme Court land when the Supreme Court can't come up with unanimous opinion and we start having to count to 5. Counting to 5 sometimes is really, really hard. So when the Supreme Court can't come up with 5 and we have to count to 5, it leads to nightmare fuel. So, not surprisingly, Bakke led to nightmare fuel. Justice Powell's opinion for himself alone would eventually come to serve as the touchstone for the analysis of race based policies, as we decided in a later opinion called Grutter. So, when we figured out how to count to 5, we said that Justice Powell's opinion, even though he only wrote for himself, was the controlling opinion. Because that's sometimes how you count to 5. It's annoying. Anyways, after rejecting 3 of the university's 4 justifications as not being sufficiently compelling, Justice Powell turned to its last interest, asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. Justice Powell found this interest to be constitutionally permissible, goal for an institution of higher education, which was entitled as a matter of academic freedom to make its own judgments as to the selection of a student body. But the university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect. Justice Powell explained an antipathy towards them was deeply rooted in our nation's constitutional and demographic history. Thank you, Alan Powell, for your Alan Parker, rather. Thank you, Alan Parker, for your continuing gift memberships. They are extensively appreciated as we continue to do this deep dive analysis here. We really do appreciate all of your continuing support. Accordingly, a university could not employ a 2-track quota system with a specified number of seats reserved for individuals from a preferred ethnicity group. Neither still could a university use race to foreclose an individual from all consideration. Race could only operate as a plus in a particular file, and even then had to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of particular applications of the applicant. So, yeah, you can't do any sort of quota. You can't do any sort of set number. You can only be a plus factor and only in combination with other factors. That's what Justice Powell kind of wrote. For years following Bakke, the lower court struggled to determine whether Justice Powell's decision was binding precedent. I'm not surprised because, again, counting to 5 can be really hard when you're talking about the Supreme Court. What is the controlling opinion? And you hope that one of them is the controlling opinion. And you don't even know then because sometimes it's a combination of opinions that's really, really annoying. So the lower courts, unsurprisingly, struggled with counting to 5 because counting to 5 is really, really hard. So when you have these split opinions, it's really, really annoying. Then in Grutter, the court for the first time endorsed Justice Powell's view that a student body diversity is compelling state interest. The Grutter majority analysis tracked Justice Powell's in many respects, including his insistence on how limits of the university may consider race in admissions. Those limits, Grutter explained, were intended to guard against 2 dangers that all race-based government action portends: The first is the risk that the use of race will devolve into illegitimate stereotyping, which implies there's such a thing as legitimate stereotyping, but I digress. Admission programs thus could not operate on a belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. So, yeah, it'd be kind of racist to assume that you admit a black person and they're going to have a black perspective, whatever that means, right? Which is one of the things that universities are doing, right? We're admitting black students because they have black perspectives. But that's kind of racist, isn't it? Yeah. I've not personally argued any Supreme Court cases, Jessica. I'd love to, but that's a pretty rare thing to be able to argue before the US Supreme Court. The US Supreme Court only hears about, mm, depends. These days, it's less. But historically, it's only heard about 120 cases. But these days, it's more like 100, and it's a little bit lower than that. So, yeah, to be one of the 160 lawyers, give or take, because of both sides. And a lot of those are the US government. So those don't really count because it's always going to be the Solicitor General's office. So if you're looking at private attorneys that argue before the US Supreme Court every year, probably looking at something like, oh, I don't know. I'm having to guess here in my head, but um you're probably looking at something like 100 tops. Yeah, you're probably looking at something like 100 tops every year. So, and a lot of those are, of course, repeat players. So, I've not had the privilege of arguing before the U.S. Supreme Court personally, but I'd love to someday because obviously it would kick ass. Oh, I didn't say I had. No, I said I'm admitted to practice before the U.S. Supreme Court. I'm licensed to practice before Texas, Virginia, and the United States Supreme Court, which is true. I am licensed to practice, but I've never argued a case before the U.S. Supreme Court. Yeah, I didn't say that I've ever argued a case. I said I'm licensed to practice. Yeah, and then a lot of those are state players too. So if you take out the federal government solicitor office and you take out the state solicitor office and you're looking at private attorneys who argue every year, maybe 80. And then a lot of those are repeat players. So yeah. But it's a fair question. Thank you for asking. I've never argued before any Supreme Court. I mean, for similar reasons, arguing Supreme Court of any state is also relatively rare because they're discretionary review. And I've never had the privilege of arguing before any Supreme Court. So, but a lot of lawyers will go their entire life without arguing before Supreme Courts because they're relatively rare. At the moment, Jessica, I don't practice any law. I'm a full-time legal commentator at the moment. Okay. My uncle has argued before the Canadian Supreme Court. That's true. I don't know how rare or not that is in Canada. I couldn't speak to that. So I don't know. Also, wouldn't be necessarily true in West Virginia until very recently, because until like 2 years ago or something, there was no intermediate appeal in West Virginia. So most states have a three-tier system: trial, appeal, Supreme Court, and West Virginia didn't have the intermediate level. So every case got appealed to the Supreme Court, and they heard all of them. So practice before the West Virginia Supreme Court was a lot more common because they were the Court of Appeals. And then recently, the West Virginia legislature decided that was kind of dumb. So I don't know if Attorney Tom. I don't believe Attorney Tom has ever argued before. I don't know that Attorney Tom has done appeals really at all. I mean, I wouldn't speak to that for sure. But Attorney Tom's work is in trial work, and there tends to be a bit of a segregation between the trial bar and the appellate bar. It's not often, although it sometimes happens, but it's not often that trial attorneys file their own appeals. Usually, I think it's fair to say usually it's someone else uh, who files appeals because they are very different practice areas. To manage these concerns, Grutter imposed one. What type of case would I argue if given the opportunity? Um, Geez, I'd argue just about anything for the privilege of it because it's such an honor. Um, I guess some sort of Second Amendment case. You know, to manage these concerns, Grutter imposed one final limit on race-based emissions. At some point, the court held they must end, recognizing that enshrining a permanent justification for racial preferences would offend the Constitution, unambiguous guarantee of equal protection. The court expressed an expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years have since passed since Grutter, but with no end of race based emissions in sight. But when the court has permitted race based college admissions only within the confines of narrow restrictions, such admission programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must, at some point, end. Respondents' admission system fail each of these criteria and therefore be invalidated under Equal Protection Clause of the 14th Amendment. Respondents failed to operate their race based admissions program in a manner that's sufficiently measurable to permit judicial review under a rubric of strict scrutiny. First, the interests that respondents view as compelling cannot be subjected to meaningful judicial review. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens. While these are commendable goals, they are not sufficiently coherent for the purposes of strict scrutiny. It is unclear how courts are supposed to measure any of these goals, or if they could, to know when they've been reached so that racial preferences can end. The elusiveness of respondents' asserted goals is further illustrated by comparing them to recognized compelling interests. For example, courts can discern whether temporal racial segregation of inmates will prevent harm to those in prison, but the question of whether a particular mix of minority students produces engaged and productive citizens or effectively trains future leadership is standardless. Yeah, and my work, of course, before has been transactional. Primarily. I haven't appeared in court many times at all because my work is mostly paper. And also some consulting work. So I've done work. Um, I've done work primarily in patent law, and then I've also done a couple minor cases in court. They were pro bono, but still. And I've also done consulting work and advisory work for various legal organizations or various um, membership organizations in the past. So my work as a lawyer has been primarily not court. It has been primarily uh, either transactional or uh, advisory, which is fine. But I definitely want to move into the future into doing appeal work. I love for my next career turn to either be a professor in court or professor of law. So I'd love to either be a professor or I'd love to do appeal work like Andrea or like one of those people and practice before. I'd like to do federal appeal work. So I'm already licensed before the federal circuit. I can simply get admission to the Fourth Circuit and Fifth Circuit. I'm sure. I just have to ask and pay them some money. because I'm licensed in Virginia and Texas. So I would presume that I can get a license before the Fourth and Fifth Circuit pretty easily. And I'd love to do some appeal cases. That'd be great. We'll see what happens in the future. Second, respondents' admission programs fail to articulate meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, respondents measure the racial composition of their classes using racial categories that are plainly overbroad, expressing, for example, no concern whether South Asian or East Asian students are adequately represented as Asian, arbitrary or undefined the use of the category Hispanic, or under inclusive, no category at all for Middle Eastern students. The unclear connection between goals that respondents seek and the means they employ preclude the courts from meaningfully scrutinize respondents' application programs. The university's main response to these criticisms is trust us. They assert the universities are owed deference when you use race to benefit some applicants but not others. While this court has recognized a tradition of giving a degree of deference to a university's academic decisions, it is made clear that deference must exist within a constitutionally prescribed limit. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete enough to permit judicial review as the Equal Protection Clause requires. Respondents' race based admission systems also fail to comply with the Equal Protection Clause's twin commands that race may never be used as a negative and may not operate as a stereotype. The First Circuit found that Harvard's consideration of race has resulted in fewer admission of Asian American students. Respondents assert that race is never a negative factor in their admissions, cannot withstand scrutiny. College admissions are a zero sum, and benefit provided to some applicants but not others necessarily advantages the former at the expense of the latter. Yeah, to add to someone is necessarily to subtract from someone else, right? It's zero sum because the college is only going to admit so many people. They're only going to admit so many people. And so among those people, to admit someone is to not admit somebody else, right? Their classes can only be so big. So to give someone else a plus is exactly the same thing as giving someone else a minus. It's mathematically the same. Giving someone an advantage is to give someone else a disadvantage. It's mathematically the same. So, yeah, to give someone an advantage is at the expense of other people. Respondents' admissions programs are infirm for a second reason as well. They require stereotyping, the very thing Grutter forswore. When a university admits students on the basis of race, it engages in an offensive and demeaning assumption that students of particular race, because of their race, think alike. Such stereotyping is contrary to the core purpose of the Equal Protection Clause. Respondents' admission programs also lack a logical endpoint as Grutter required. Respondents suggest that the end of race based admissions programs will occur once meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class and comparing it to some other metric, such as the racial makeup of the previous incoming class or the population in general, to see whether some proportional goal has been reached. The problem with this approach is well established. Outright racial balancing is patently unconstitutional. Respondent's second proffered endpoint, when students receive the educational benefits of diversity, fares no better. As explained, it's unclear how a court is supposed to be able to determine if or when such goals will be adequately met. Third, respondents suggest the 25-year exception to Grutter means that race-based preferences must be allowed to continue until at least 2028. The court statement in Grutter, however, reflected only the court's expectation that race-based preferences would, by 2028, be unnecessary in the context of racial diversity on college campuses. Finally, respondents argue that the frequent reviews they conduct to determine whether racial preferences are still necessary obviates the need for the endpoint. But Grutter never suggested that periodic review can make an unconstitutional condition constitutional. Because Harvard and UNC's programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve stereotyping, and lack meaningful endpoints, These admission programs cannot be reconciled with the guarantees of the Equal Protection Clause. I'm still wondering how Harvard is bound by the Equal Protection Clause. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected their applicant's life, so long as this discussion is concretely tied to a quality of character or unique ability that a particular applicant can contribute to the university. Many universities have far too long wrongly concluded the touchstone of an individual's identity is not challenge bested, skills built, or lessons learned, but the color of the skin. This nation's constitutional history does not tolerate the choice. Roberts delivers the opinion which Thomas, Alito, Gorsuch, Kavanaugh, and Barrett join. Thomas concurs, Gorsuch concurs, Kavanaugh concurs. Sotomayor dissents in which Kagan and Jackson join. Jackson files a dissent in which Sotomayor and Kagan join. Jackson took no part in consideration of the case from UNC because I believe she had heard that case. No, apologize. Jackson took no part in consideration of the case dealing with Harvard because she had some particular ties to Harvard, so she cast no vote on that. So this is 6-3 and 6-2, respectively. All right, I need to read a little bit more to understand how the Equal Protection Clause on the 14th Amendment applies here. So let's scroll a little bit more because I'm either missing something or well, I'm definitely missing something. So let me scroll and see what's going on here. Well, I could just scroll for the words equal protection probably. Uh, okay, let's see if I can find what I need so I can understand what the Supreme Court is trying to tell me. Okay. So here's a footnote apparently that tries to solve this problem. We're going to solve this problem in a footnote. All right. Title VI provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. We've explained that discrimination violates the Equal Protection Clause of the 14th Amendment, committed by an institution that accepts federal funds, also constitutes a violation of Title VI. Well, yes, that's true. If it violates the Equal Protection Clause, it would violate Title VI, but not necessarily the other way around. We accordingly evaluate Harvard's admission program under the standard of Equal Protection Clause itself. That's wrong. That's wrong. Yeah, to violate the Equal Protection Clause violates Title VI, but the reverse is not true. It also doesn't suggest that Harvard is bound by the Equal Protection Clause. This is wrong. This doesn't make any sense. What am I missing? This is the court has remarked that Title VI is coextensive with the Equal Protection Clause. We've explained that discrimination that violates the Equal Protection Clause committed by an institution that accepts federal funds also constitutes violation Title VI. Title VI prescribes only those racial classifications that will violate the clause. As Justice Gorsuch points out, Title VI makes no allowance for racial consideration in university admissions. This is Put differently, they read Title VI to prohibit recipients of federal fund from doing whatever the Equal Protection Clause prohibits states from doing. Okay, if that's what they mean, but they didn't write it that way. They wrote it. They wrote it a very weird way. So to say that Title VI is the same thing as the Constitution, and to say that Harvard is bound by Title VI, and to say that therefore they violate Title VI because it's the same thing as the Constitution makes sense. But they said that Harvard is actually violating the Equal Protection Clause, which doesn't make sense. Yeah, the Equal Protection Clause in Title VI might mean the same thing, but that doesn't mean that Harvard is bound by the Equal Protection Clause. They're bound by Title VI. That they mean the same thing, fine. But then that's the entire point of the statute. The entire point of the statute is to take the constitutional language and make it broader, which you can do by statute. You can do that. The Equal Protection Clause applies to the government, and only the government. And you want to apply to private actors so that you pass Title VI. Okay. So Harvard is violating Title VI. They're not violating the Equal Protection Clause. Just because they mean the same thing doesn't mean that Harvard is violating the Equal Protection Clause. That doesn't make any sense. Margaret, I know everything about this case. I followed this case every step of the way. I filed this at the trial level. I filed this at the Court of Appeals level. I filed this at the oral argument level. I filed this. I filed this at the briefing level. I know everything about this case. I am incredibly well informed about this case. This doesn't make any sense to me. The Supreme Court's wrong. I'm struggling because what they're saying doesn't make any sense. I'm struggling because what they're saying doesn't make sense. Yeah, see, here's the problem. The Equal Protection Clause reads no state shall deny any person within its jurisdiction the equal protection of the laws. Harvard is not the state. The Equal Protection Clause is irrelevant to Harvard. You can't say Harvard violates the Equal Protection Clause. It doesn't make sense. The Equal Protection Clause applies to states, and Harvard isn't the state. UNC is the state, but Harvard's not the state. The Equal Protection, yeah, Gorsuch says it. The Equal Protection Clause operates on states. It does not purport to regulate the conduct of private parties. By contrast, Title VI applies to recipients of federal funds, covering not just the way many state actors, but the way many private actors do too. In this way, Title VI reaches entities and organizations the Equal Protection Clause does not. Right, exactly. So you can't say Harvard violates the Equal Protection Clause. You say Harvard violates Title VI. It doesn't make sense to say Harvard violates the Equal Protection Clause. You can say they violate Title VI, and Title VI means the same thing as the Equal Protection Clause, but they're still violating Title VI. Title VI's point is to bind a actor who takes federal funds in the same way it would bind the state. Okay. Title VI bears independent force beyond the Equal Protection Clause. I tend to agree. Yeah, Title VI bears independent force beyond the Equal Protection Clause. Right. That's the whole point of Title VI. The Equal Protection Clause binds the state. Title VI binds people beyond the state. Yes, Title VI has independent force beyond it applies to different groups of people. It applies to different groups of people. The fact that it applies in the same way is irrelevant. You know, it would be a little bit like, I don't know what a good analogy would be. It would be a little bit like passing a statute that says no dogs in the park, and then passing a different statute that says no cats in the park. In this hypothetical, these are two completely different statutes. This particular Congress, for whatever reason, didn't write no dogs or cats. Like they could have just wrote that in like one thing, but they didn't. What this hypothetical Congress wrote was no dogs in the park. And then in a completely different statute writes no cats in the park. Right. And then you're like, okay, what does that mean? And you're like, well, okay, what does park mean? Right. So let's imagine a hypothetical case where you're like, okay, what does park mean? All right. Well, okay. Park means a park means a institution created by the state park service that is funded by the state park service and administered by the Bureau of Parks. That's what parks are. That doesn't apply to someone's backyard. Backyards are not parks. Why are they not parks? Because parks are only those things that are created by the Bureau of Parks and administered by the Bureau of Parks, right? So you've interpreted the word parks, but then you're like, okay, the word parks means the same thing in both statutes. Okay. So when you said no dogs in the park, and then you said no cats in the park, you meant the exact same thing for parks. But now you have a cat, and you're like, they violated the statute for dogs. I don't know if this analogy is working. It's what I came up with. It may not be a great analogy. Maybe I'll think of something else. Yeah, I don't. They kind of mean like it's as if they violated the Equal Protection Clause, which I okay. The same standard that applies under the Equal Protection Clause guides the court review under Title VI as the majority correctly recognizes. Petitioner could prevail under Justice Gorsuch's statutory analysis. There'd be no reason for the court to reach the constitutional question, which also would be like a pretty basic thing. Gorsuch is right. If we can decide this under the statute, we don't need to decide this under the Constitution. Why are we not deciding this under Title VI? Why are we mentioning equal protection at all? Is a good question at this point. That's weird. Because, yeah, this is what Justice Sotomayor writing in dissent? Yeah, Justice Sotomayor writing in dissent has a point. Because we do have this principle of like constitutional avoidance. If we can decide something under a statute, we typically do. So why are we talking about equal protection at all? Is actually a pretty good question. Why don't we just talk about Title VI and call it a day? And we don't even talk about the Constitution because we don't have to. So Justice Gorsuch is over here like, let's just decide this under the statute. And the other 8 members of the court are like, nah. Harvard argues the same. Well, that's even more reason to decide it under the statute. If Harvard argues it's the same, then great, then decide it under the statute. And we don't even have to answer the constitutional question. I mean, you're the one that says it's the same, so we'll decide under the statute, and we won't even talk about the Constitution. Is it possible the Supreme Court's trolling me? They might be trolling me a little bit. Hmm. I mean, they say Harvard admissions violates the Equal Protection Clause of the 14th Amendment. It's right there. Harvard's admission program violates the Equal Protection Clause of the 14th Amendment. But it literally can't. It literally can't violate the 14th Amendment. Uh, uh, unless you say the very act of unless you say the very act of accepting money turns you into a state actor, but that goes in the face of a whole bunch of precedents, so that's not right. Respondents' admission systems, however well intended, must be invalidated under the Equal Protection Clause of the 14th Amendment. And apparently, race-based admissions at military colleges can still continue for the moment. Am I the only one having a problem here? Harvard and UNC programs cannot be reconciled with the guarantee of the Equal Protection Clause. That doesn't make sense. It doesn't make sense. It doesn't make sense. Uh, yeah. There's only one part of the Constitution which binds private action, and that's the 13th Amendment, because the 13th Amendment says it does. The, there's no other provision of the Constitution which binds private action. So if you want to say an individual is violating the 13th Amendment, then okay, maybe, because private individuals can violate the 13th Amendment because it says they can. But no other provision of the Constitution applies to private actors. Harvard is not the government. Harvard is a private college. It has been forever. It's always been private. It has never been state, ever. They accept federal funds, that's true. But it's not the act of accepting federal money that turns them into a state actor, because there's lots of cases that say that, right? Merely accepting government money doesn't necessarily turn you into a state actor, depending on what you do with the money or how you like there. But the mere act of accepting money doesn't turn you into a state actor. The mere act of being licensed by the government doesn't turn you into a state actor. And there's plenty of precedent on that. And so they say Harvard is bound by the Equal Protection Clause. I'm like, no, they're not. They're bound by Title VI. Now, I don't have any problem. I don't have any problem with the Supreme Court saying Title VI is coextensive in its reach, in sort of its subject matter to the Constitution, because that makes total sense, right? The Constitution sets a floor, not a ceiling. We've discussed this many times, right? The Constitution sets a floor, not a ceiling. And so the legislature can always extend more rights. So I don't know what the scenario would be exactly, but well, you know what the scenario would be, because when it comes to like constitutional language, we do this all the time in state constitutions, right? State constitutions often mirror the language of their federal counterparts. And most of the time, the state Supreme Court say that their language is coextensive, but every once in a while they don't say that. Every once in a while you'll see a decision. It's like, nope, under our Constitution, we require more. We require more. It's like, okay, you can do that. You can require more. That's fine. We've seen that, for example, in traffic stop cases with search and seizure, right? We've seen Pennsylvania comes to mind recently, where Pennsylvania made a decision under its state constitution that would not be required under the federal constitution. And I'm like, okay, that's fine. You can do that, right? You can do that. That's fine. Um, so Congress passed this thing, Title VI, that said, okay, if you take money, yay money, you can't discriminate on the basis of race, which is how the federal government often gets both states and private actors to do its bidding, right? The money is the trap. They do it for states and they do it for private actors. It's like, we can't regulate you directly, but what we can do is offer you money. You like money. Yay, money. And so you take money. And now that you've taken our money, we can put conditions on that money. such as you are now bound by all these. You didn't read the terms and agreement. You didn't read the terms and conditions, did you? You just clicked I agree and I agree real fast, right? Didn't you? You just clicked I agree. Well, here's all the things that came along for the ride that you didn't read about, Harvard. Not that you're not like the best law school in the nation and should be able to figure this out, but that's okay. We'll explain it to you anyway. That you're now bound by this and you can't discriminate on the basis of race. Okay, in what way can't we discriminate on the basis of race? In what way can't we? Okay, the way we can't is exactly the same as it is to the state. So the nature of the way we can't discriminate is in the same nature as it is for the as it is for the states. Now, incidentally, by the way, this doesn't have to be true. It could be lesser or greater because this is not tied to the Constitution, right? This is tied to private actors. So it could be okay. The state can't discriminate on race, and we could make it so that the private entities are more bound than their state counterparts. So, like, states can't discriminate, but you really can't discriminate. You extra can't discriminate. So, we could do that. And incidentally, that's how Gorsuch reads it, by the way. He reads it as Title VI is more than the Constitution requires. But fine. Or we could actually go the other way too. We could actually say it's less. Okay, states can't discriminate against people on race, but you can discriminate a little bit. You can discriminate a little bit, right? And then we would describe what that is, right? Because we can kind of do whatever we want here. So Congress could have said you can't discriminate more, which is what Gorsuch says. You can't discriminate less, which apparently no one says. And then 8 members of the court say what they meant is exactly the same. Okie dokie, it's exactly the same. But that doesn't mean that Harvard violates the Equal Protection Clause. That's the mistake. And the Supreme Court writes it over and over again that they violate the Equal Protection Clause, and that's a mistake. They don't. They violate Title VI. They violate Title VI, not the Constitution. And what's even weirder about the whole thing is we could also decide it for UNC under Title VI because Title VI could bind UNC on top of the Constitution, right? So, like, no state shall do X by the Constitution, but we could also pass a statute that says you can't do the same thing, right? And there is this idea of constitutional avoidance where we don't want to where we don't want to decide things under the Constitution if there's another way to get there. And here there's a very readily easy way to get there. So I don't even know why we're talking about equal protection at all now. If Title VI is coextensive with the Equal Protection Clause, then the easier way to do this is just to ignore the Equal Protection Clause exists and just be, okay, both Harvard and UNC, you are violating Title VI. And we say nothing about the Constitution. We render no opinion because we don't do that. We don't render opinions on the Constitution when we don't have to. We simply say that you're violating Title VI and call it a day. But we didn't do any of those things. And I'm very, very confused. Isn't discrimination based on race and unequal protection? Sure, it is. But if we can decide it on statute, we do. So I'm not saying, listen to me carefully. Right? I'm not saying that they're wrong for saying that UNC violates the Equal Protection Clause. I am saying they're a little weird for mentioning it, though. Because normally we don't do that. Normally, if we can decide it under a statute, we do. We don't decide it under the Constitution. So does it violate the Constitution? I don't know, but it violates Title VI would be the more typical answer. And then you can treat Harvard and UNC in the same breath because they both are violating a statute. And does UNC violate the Constitution? We're not going to tell you. We're not going to tell you. But then they say that Harvard violates equal protection, which is wrong. and raises problems. And I don't, it looks like no member of the Supreme Court noticed, or no member of the Supreme Court wants to talk about it. Because I looked for everywhere equal protection occurred, and I was waiting for someone to say, um, by saying Harvard violates equal protection, you're raising a whole host of problems. Because if Harvard is bound by the Equal Protection Clause, then the next logical question is what other private actors are bound by the Equal Protection Clause and under what circumstances? See, you just went from a per se rule where it's like, okay, private actors are never bound by the Equal Protection Clause. Never, ever, ever. Private actors are never bound by the Equal Protection Clause. Ever, ever, ever. And now you've moved to a position where you said, okay, in this situation, Harvard is bound by the Equal Protection Clause. And I'm all over here like, wait, what? Because if Harvard is bound by the Equal Protection Clause under this circumstance, under what circumstances are other private entities bound by the Equal Protection Clause? And I can't be the only one who notices this, right? I know I'm a reasonably smart guy, but I'm not like, it can't possibly be true that I'm the only one who notices this between the members of the Supreme Court and all their many, many clerks, and be like, this doesn't make sense. Why did you write it this way? Why did you write it this way? Because you have just opened up a whole new possible can of worms. Because now I, as a lawyer, can suddenly try something I wasn't able to do before, which is now I can sue. Now I can sue private entities for violation of the 14th Amendment. Apparently. Read on. I mean, I read every place the word equal protection applies. I looked, I searched, you saw me search like every word, every place the words equal protection applies. And they try to deal with it in a footnote. Their footnote is their grand contribution to try to reconcile this issue. Yeah, they try to deal with this in a footnote, is their grand contribution to the whole thing. Title VI provides no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefit of, or subject to discrimination under any program or activity receiving federal financial assistance. We have explained that discrimination that violates the Equal Protection Clause of the 14th Amendment committed by an institution that accepts federal funds also constitutes a violation of Title VI. Although Justice Gorsuch questions that proposition, no party asks us to reconsider it. We accordingly evaluate Harvard's admission program under the standards of the Equal Protection Clause itself. That's wrong. That's wrong. Pretty sure they're saying Title VI is necessarily at least as restrictive as EP. Thus, if EP has been violated, Title VI has also necessarily been violated. If you're the state, yeah, that would make sense. But it doesn't make sense if you're Harvard. really, really weird. I'm sorry we're spending so much time on this. I'm sorry we're spending so much time on this discussion, but this sentence, we're evaluating Harvard's administration program under the standards of the Equal Protection Clause itself, doesn't make any sense. It doesn't make any sense. And it raises the question, if you're evaluating Harvard, which is a private institution, under the Equal Protection Clause, under what other circumstances are you looking at private actors under the Equal Protection Clause? You don't know what I'm getting hung up on? The Supreme Court is saying it doesn't make any sense. It doesn't make any sense. Even if Harvard went to the Supreme Court and just actively said, yeah, it's the Equal Protection Clause, guys. We want to be judged under the Equal Protection Clause. This would still be wrong. Just because Harvard argues it doesn't make it like mean the Supreme Court has to decide it that way. That doesn't make any sense. Harvard could go in and be like, yep, we're bound by the 14th Amendment. We sure are. We are bound by the 14th Amendment. We are totally bound by the language of the 14th Amendment. That's a legal argument. Doesn't mean that Harvard's right. So Harvard's argument or failure to argue it doesn't seem to solve the problem. Is the court treating Harvard as a state entity? I don't know. Read the line above. I read the line above, Matova. I read it. It doesn't make any sense. I read it. You want me to read it again? I'll read it again just for you. Where is it? Title VI provides that no person in the United States shall, on ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. We have explained that discrimination that violates the Equal Protection Clause of the 14th Amendment, committed by an institution that accepts federal funds, which doesn't make any sense, also constitutes a violation of Title VI. Although Justice Gorsuch questions that proposition, no party asks us to reconsider it. We accordingly evaluate Harvard's admission program under the standards of the Equal Protection Clause. And they're even citing a goddamn footnote. They're citing a goddamn footnote. And what does this proposition actually stand for? Let's go pull this thing and see if that answers any questions. No. Yep. 276 part note 23. What the hell is this? All right, hold on. Hold on. All right. So they say 276 note 23. From a footnote? We have explained that discrimination that violates the Equal Protection Clause of the 14th Amendment committed by an institution that accepts federal funds also constitutes a violation of Title VI. With respect to 1981, we explained that provision was meant by its broad terms to prescribe discrimination in the making and enforcement of contracts in favor of race. Furthermore, we explained that a contract for educational services is a contract for the purposes of 1981. I need to continue down the rabbit hole. Hold on. I need to continue down the citation rabbit hole. Let's see. $281. In Guardians, the court made clear that under Bakke, only intentional discrimination was forbidden. We say in Alexandria is true today. Title VI itself directly reaches only instances of intentional discrimination. How's that have anything to do with anything? It doesn't speak to that proposition. Hold on. United States versus Fordyce. In another footnote. How many footnotes can we cite, guys? Jesus Lord. 717.32. No. All right. 717.32, note 7. Oh, Lord. Note 7. The Court of Appeals misanalyzed the Title VI claim. The court stated we're not prepared to say defendants have failed to meet their duties outlined in regulation. The court added need not discuss the scopes of Mississippi's duty under regulations because the duty outlined by Supreme Court in Bazemore controls the Title VI case. It will be recalled, however, the relevant agency and the court specifically found no violation of Bazemore. Insofar as they failed to perform the same factual inquiry and application, Court of Appeals' reliance to avoid constructing a similar analysis was inappropriate. Private petitioners reiterate in the court their assertion the state system violates Title VI, citing a regulation of the statute when require states to take affirmative action. Our cases make clear that parties do not disagree. The reach of Title VI's protection extends no further than the 14th Amendment. Okay, that I understand. We thus treat the issues in this case as are implicated under the Constitution, which makes sense for a state actor. Yet Title VI goes no farther than the 14th Amendment. So as to the state actor, that makes sense. We have one more site in the rabbit trail. Let's take a look at this and see if that adds any illumination to this problem I'm having. All right, let's see. This is 469 US 287 293. All right, let's take a look at 293 and see if it has anything to teach me on this issue. Okay. No opinion commanded a majority, and guardians and members of the court offered a wide variety of interpretations of Title VI. Nonetheless, a two-pronged holding of the nature of discrimination prescribed by Title VI emerged. First, the court held that Title VI itself directly reached only instances of intentional discrimination. Second, the court held that actions having unjustifiable disparate impacts on minorities could be redressed through agency regulations designed to implement Title VI. In essence, then, we held Title VI is delegated to the agencies the first instance of complex determinations of what source of programs. This does nothing to help me. So, uh, for the proposition that Title VI is coextensive with the Equal Protection Clause, fine. I have no problem with the idea that Title VI is coextensive with the Equal Protection Clause, but they apply to different groups of people. Title VI might apply to the state too. I have no particular problem with that either. If you want to say that Title VI applies to the state, I'm fine with that. If you want to say Title VI is coextensive with the Equal Protection Clause, I'm fine with that. But to say Harvard is violating the Equal Protection Clause, no. This doesn't make any sense. This makes zero sense. This makes none of the sense. I don't get it. I don't get it. This is so fucking bizarre. Yeah, I think Paul, you're not wholly wrong. I think that's kind of what they I think that's what they're trying to say. It's just not what they wrote. I think the court is saying that discrimination is defined by 14A, and then they're using that the definition to determine violation of Title VI. Yeah, I think that's what they mean to do, but that's not what they wrote. That's the pro. I think your saving construction is correct, but the language is like in my face, man. Harvard's program violates the Equal Protection Clause of the 14th Amendment. There's not a lot of ways to interpret that. You know what I mean? We accordingly evaluate Harvard's admission program under the standards of the Equal Protection Clause itself. So I'm like, I'm not sure that like I appreciate your saving construction, um, Dave. And you know, if you want to make that argument in court, I think there's a viable line of argument. I just think that the opposite line, unfortunately, from the language seems to be well open. I don't think they're saying Harvard is violating the Equal Protection Clause. I think they're saying what Harvard does would violate the Equal Protection Clause. Yeah, that's probably what they meant to write. That's what they should have written. But I'm not sure it is what they actually wrote. Yeah. Eh. There's no good reason to believe respondents will comply with the Equal Protection Clause. Why does Harvard have to comply with the Equal Protection Clause? For the reasons provided above, the Harvard and UNC admissions program cannot be reconciled with the guarantees of the Equal Protection Clause. That's not the standards of the Equal Protection Clause. That's not the scope of the Equal Protection Clause. That is the guarantee of the Equal Protection Clause. Harvard's admission program cannot be reconciled with the guarantees of the Equal Protection Clause. That only makes sense if Harvard is bound by the Equal Protection Clause. I appreciate everyone saving constructions over here, desperately trying to avoid the clear writing of the Supreme Court, but the Supreme Court doesn't seem to be really letting us do that right now. The race-based admission systems that respondent employ also fail to comply with the twin commands of the Equal Protection Clause that race may never be used as a negative and may not operate as stereotype. Are you sure that the United States Supreme Court hasn't just written that Harvard is actually bound by the Equal Protection Clause in and of itself? Because I'm not sure that isn't what they wrote. I think they wrote that Harvard is bound by the Equal Protection Clause. They keep talking about. I appreciate everyone's attempt at the saving constructions over here, but I don't know, man. I don't know. That doesn't mean Harvard violated the Equal Protection Clause. Are we reading the same text? Are we reading the same text? It doesn't mean Harvard violated the Equal Protection Clause. Are we reading the same text? I'm not sure we're reading the same text. David says, I agree with you. It's terrible writing, but I'm sure. David, I want you to be right. I certainly want you to be right. But anyone who knows anything about the Supreme Court knows that Supreme Court arguments have been based off less. And so, I mean, the Supreme Court itself just justified this on a string of footnotes, citing to other strings of footnotes. It's like it's turtles all the way down, except the turtles are footnotes. And so, like, yeah, what they really meant was, yeah, but what they actually wrote was, and I don't think you could be. I think now apparently now as a lawyer, apparently now I can go into court and I can say with a straight face that this private actor is bound by the 14th Amendment. That is apparently now an argument I can make. And all your arguments to the contrary about how that's ridiculous are probably correct. But the language, though. So there is an exciting new opportunity out there. There's an exciting new opportunity. And also, incidentally, while we're at it, while we're just breaking everything down completely to hell, if private entities, so there's only explicit language, that private entities are bound by the 13th Amendment. The thinking up until this, like literally, like right now, the thinking up until right now was that private entities are not bound by the Constitution. This language, on its own terms, seems to strongly suggest to my mind that Harvard is bound by the Constitution, at least as to the 14th Amendment. Okay, here's the next logical question. If Harvard is bound to the 14th Amendment, what other amendments are they bound to? And as they are bound to those amendments, what other institutions are bound by the Constitution? Is Harvard bound by the Second Amendment now? Before answering no, I counsel you to read this opinion again. Because apparently we're deciding this under the Equal Protection Clause itself. So apparently Harvard's bound by the Equal Protection Clause itself. Okay, is it bound by the Second Amendment? No? Are you sure? Are you really sure? Yeah. And I don't think I'm really stretching the language. I respectfully submit that my compatriots over here who are desperately trying to avoid the writing of the Supreme Court are more stretching the language than me. I don't think the Supreme Court really meant what it wrote, but it wrote that. And if you don't think you can convince a federal judge somewhere that they really meant that, you're out of your mind. This opens up a whole new world of fun and exciting opportunities for us all. Uh, the issue is Kurt missed all the parts where Robert said Title VI requires federally funded institutions to follow the 14th Amendment. Yeah, that doesn't make any sense. That doesn't make any sense. That isn't the problem. I didn't miss those parts. That's the problem. Yeah, that's the problem. I didn't miss the parts where Robert said that Title VI requires federally funded institutions to follow the 14th Amendment. My problem is that doesn't make any sense. If you didn't miss those parts, there's no problem. There's a big problem. There's a big problem. There's an incredible problem. There's a massive problem. I'm just gonna go Twitch. I'm just gonna go lie down and Twitch uncomfortably for a while. Uh, okay. Yeah. Yeah. So yeah, these are some of the problems. These are some of the fun and exciting questions we now get to ask. Apparently, these are some of the fun and exciting questions we now apparently get to ask. If a grocery store takes any form of state-funded welfare, are they under the Equal Protection Clause? I don't know. That's apparently a question that I now need to ask. I thought the answer was no, but apparently the answer isn't no. Apparently the answer might be yes. So as the grocery store takes that COVID relief money, are they suddenly subject to the Equal Protection Clause? I don't know. Maybe. I'm not sure I could write an op-ed. This is like a law review. I might have to write a law review now. I have to write a note. Uh, I have to write. I have to write. I have now have to write a note. The tentative title of the note is "The 14th Amendment Implications on Private Actors." Uh, I have to write a 50-page note now explaining this. That's what I have to do. That's a lot of work. And then other lawyers can yell at me about how I'm misreading it, and then lawyers can agree with me. I'm gonna pick a fight. It looks like I'm picking a fight now in the legal community. I'm gonna write a note, and then Gosney will write a note, and we're gonna pick a fight. It's gonna be great. Fun. Thus, that brings us to the end of discussion for the moment of the Supreme Court case of Students for Fair Admissions versus Harvard versus UNC. And the takeaway, at least for the moment, is that race based discrimination is banned, at least as it applies to non military schools, because there's a footnote that says maybe the military schools, but we're not going to reach that decision today. But as to that, we'll see. As to these schools, however, not so much with the race based administration. Race based is wrong. And we'll see how that all progresses with all that, at least for a moment. That brings us to the end of discussion of this story. I I, I need access to Westlaw or Lexis, and I need someone to publish my law review paper. Okay, so how y'all doing? How y'all doing? You doing fine? Okay. Thinking of taking the LSAT. Any advice? Yeah, don't go to law school. Don't go to law school. There's my advice. That's my advice. Don't go to law school. It's a silly place. It's a silly place. Don't go to law school. Stay away. Don't take the LSAT. Take up fishing instead. Fishing is fun, I hear. Could be calming and fun. Emily's going to start in a minute. Okay, well, I look forward to losing my audience to Emily D. Baker then. Yeah, you're more than welcome to stay here and learn more about Supreme Court. It can't possibly get any worse than this. For today's Supreme Court decision, we turn our attention to religious accommodation in the workplace. We have the case of Jeff, who is a postal employee, but critically, he does not want to work on Sundays. Now, normally, this wouldn't be a problem for Jeff. The postal office doesn't deliver a lot of mail on Sunday. They do deliver express mail 365 days a year, but of course, that's a pretty small part of the business. So, Jeff was able to avoid work on Sundays. But then the USPS teamed up with Amazon and other companies for last mile delivery. And suddenly they had a lot more work to do than they did before. And that was good for the postal office because decline of traditional mail. But all these package delivery companies need the postal service because, well, they could provide all those trucks to go everywhere. So Jeff suddenly had to work Sundays, and Jeff was sad. So we have to learn a little bit more about whether or not he can be forced to work on Sundays or not. Let's get started with this. The petitioner is an evangelical Christian who believes for religious reasons that Sunday should be devoted to worship and rest. In 2012, he took a mail delivery job with the Postal Service. The position did not generally involve Sunday work, but that changed over time as USPS began to agree facilitating Sunday deliveries for Amazon. To avoid working on Sundays on a rotating basis, he initially transferred to a rural station that did not make these Sunday deliveries. After Amazon began delivering at that station as well, he remained unwilling to work on Sundays, and the postal office redistributed the Sunday deliveries to other staff. He received a progressive discipline for failing to work on Sundays and eventually resigned. So, forced into resignation based on religious reasons. The petitioner sues under Title VII of the Civil Rights Act, asserting that USPS could have accommodated his Sunday Sabbath practice without undue hardship on the business. The district court grants summary judgment to the Postal Service. The Third Circuit affirmed based on this court's decision in Transatlantic, in which they constructed to mean that requiring an employer to bear more than de minimis cost to provide religious accommodation is an undue hardship. So you have to do something unless it would cost any sort of money at all. So you don't have to provide accommodation if it provides you any sort of burden at all, was the standard. The Third Circuit found that this de minimis cost standard was met here, concluding that exempting him from Sunday work had imposed on his coworkers, disrupted the workplace, and diminished employee morale. So, under the case law as it currently exists, you could only get an accommodation if it provided no burden to your employer, which obviously is a pretty easy threshold to meet. So, is that the relevant law? What am I doing? Held, the Title VII requires an employer that denies a religious accommodation to show the burden of granting an accommodation would result in a substantially increased cost in relation to the conduct of its particular business. So we went from a de minimis standard to a substantial increase. So employers now will be forced to accommodate people unless it will be a significant burden, which I'm supposing the Supreme Court will tell us more about. This case presents the court's first opportunity in nearly 50 years to explain the contours of the law. The background of that decision helps the court to explain this case. Title VII of the Civil Rights Act makes it unlawful for covered employers to fail or refuse to hire or discharge any individual or otherwise discriminate against an individual with respect to compensation, terms, condition, privileges of employment because of religion. So you can't fail to hire them, you can't fire them, and you can't discriminate against them as it relates to any workplace benefit. So you can't not give them a benefit, whatever that would be. Employee parking, uh, access to a break room, whatever. If you provide a benefit to employees of any description, you have to provide that to every employee, at least as it relates to religion. Subsequent regulations issued by the EEOC obligated employers to make reasonable accommodations to religious needs whenever doing so would not create undue hardship in the conduct of business. In the 1970s, the Sixth Circuit held that Title VII did not require an employer to accede to or accommodate a Sabbath religious practice because to do so would raise grave Establishment Clause questions. So the Sixth Circuit said that an employer doesn't need to accommodate religion because that would itself propose a religious problem, right? The employer would be forced to recognize religion. This court affirmed that by an evenly divided vote, which means that there is no precedential authority. That's what happens when there is a divided vote by the Supreme Court. It's without precedential authority. So the Supreme Court agrees, but doesn't set a precedent. Congress responded by amending Title VII in 1972 to track regulatory language and clarify employers must reasonably accommodate an employee or prospective employee's religious observation practice unless the employer is unable to do so without undue hardship in the conduct of the business. Have I thought about becoming a case law professor? Sure. I don't know how I would go about doing that, to be honest. I don't know how I'd go about becoming a professor. I don't know how to go about doing that. But if someone out there wants to hire me as a professor, I'm available. Hardison concerned an employment dispute that arose prior to 1972 amendments. In 1967, Trans World Airline hired a person to work in a department that operated 24 hours a day, 365 days a year, and planned an essential role for TWA, providing parts needed to repair and maintain aircraft, which kind of work every day of the year. Hardison later underwent a religious conversion and began missing work to observe the Sabbath. Initial conflicts with Hardison's work schedule were resolved, but the conflicts resurfaced when he transferred to another position in which he lacked the seniority to avoid working during the Sabbath. Attempts to accommodate failed, and TWR discharged him for insubordination. Hardison sued TWA and the union, and the Eighth Circuit sided with Hardison. The Eighth Circuit found that reasonable accommodations were available to TWA and rejected defense establishment clause arguments. This court grants certiorari. TWA's petition for certiorari asked this court to decide whether the 1972 amendment of Title VII violated the Establishment Clause as applied by the Eighth Circuit, particularly insofar as the decision had to be approved by accommodating that allegedly overrode seniority rights granted by relevant collective bargaining agreement. At the time, sought that the court's now abrogated decision in Lemon, which adopted a test under which any law whose principal or primary effect was to advance religion was unconstitutional, posed a serious problem for the 1972 amendments. Ultimately, however, constitutional concerns played no on-stage role in the court's decision. Instead, the court's opinion stated that the principal issue was whether Instead, the court's opinion stated that the principal issue on which TWA and the union came to this court was whether Title VII requires an employer and a union who have agreed on a seniority system to deprive senior employers of the seniority rights in order to accommodate a junior employer's religious practice. The court held that Title VII imposed no such requirement. This conclusion the court found was supported by the fact that seniority systems are afforded special treatment under Title VII itself. Applying this interpretation of Title VII and the disagreeing with the Eighth Circuit evaluation of the factual record, Applying this interpretation of Title VII and disagreeing with the Eighth Circuit's evaluation of the factual record, the court identified no way in which TWA, without violating seniority rights, could have feasibly accommodated Hardison's request for exemption for work on the Sabbath. The parties have not focused on determining what increased costs amount to undue hardship under Title VII separately from the seniority issue. But the court's opinion in Hardison contains off-quoted sentence. To require TWA to bear more than de minimis cost in order to give Hardison Saturdays off is an undue hardship. Although many later courts viewed this line as authoritative interpretation of the statute's term of undue hardship, the context renders this reading doubtful. In responding to Justice Marshall's dissent, the court described the governing standard quite differently, stating 3 times that accommodation is not required when it entails substantial costs or expenditures. Even though Hardison's reference to de minimis was undercut by conflicting language and was fleeting in comparison to discussion of the principal issue of seniority rights, lower courts have latched on to de minimis as the governing standard. To be sure, many courts have understood that protection for religious adherents is more than de minimis might suggest when read in isolation. But diverse religious groups tell the court that de minimis standard has used been to deny even minor accommodations. That EEOC has also accepted the case as prescribing more than de minimis cost, though it has tried to soften its impact, cautioning against extending the phrase to cover such things as administrative costs involved in reworking schedules, the infrequent or temporary payment of permanent premium wages for a substitute, and voluntary substitutes and swaps when they're not contrary to the bona fide seniority system. Yet some courts have rejected even the EEOC's gloss on de minimis, rejecting accommodations the EEOC guidelines consider to be ordinarily required. The court agrees with Solicitor General that the case law does not compel courts to read more than de minimis standard literally, or that any manner that underlines Hardison's reference to substantial costs. The court holds that showing more than de minimis costs, as that phrase is commonly used, does not establish undue hardship under Title VII. Hardison cannot be reduced to that one phrase. In describing an employer's undue hardship defense, Hardison repeatedly referred to substantial burdens, and for that formulation better explains the decision. The court understands Hardison to mean undue hardship is shown when a burden is substantial in the overall context of an employer's business. The fact-specific inquiry comports with Hardison and the meaning of undue hardship in protected speech. To determine what an employer must prove to defend denial of religious accommodation under Title VII, the court begins with Title VII's text. The statutory term hardship refers to, at minimum, something hard to bear and suggests something more severe than a mere burden. If Title VII said only the employer need not made to be suffer a hardship, an employer could not escape liability simply by showing an accommodation would impose some sort of additional cost. Adding the modifier undue means that the requirement, burden, or adversary must rise to the excessive or unjustifiable. Understood this way, undue hardship means something very different from the burden that's merely meant by de minimis, e.e., very small or trifling. The ordinary meaning of undue hardship thus points to a standard closer to Hardison's reference to substantial additional costs or substantial expenditures. Further, the court's reading of statutory terms comports with pre-1972 EEOC decisions, so nothing in that history plausibly suggests that undue hardship in Title VII should be read to mean anything less than its meaning in ordinary use. And no support exists in other factors discussed for the parties reducing it to more than de minimis cost line. Thank you very much, Eddie, for saying that I have great analysis. I try very, very hard. I dedicate myself very, very hard to the study of law, which is why I give the Supreme Court notes, and now I'm contemplating writing a note, which is a pretty serious undertaking. Because I'm like, okay, Supreme Court, I'm not 100% sure you understand what you just read, and I'm not sure the rest of the bar necessarily understands what you just read, but that's okay. I'm going to write a note and tell everybody about it. I'm going to tell everyone about what you just wrote because I'm not sure other people spotted it, but that's okay. I did. I want to write a note about it, which is a massive pain in the ass. And now I need Westlaw or LexisAccess because I need to be able to do some unbelievably deep dive research. It has been a hot minute since I've written a note. So, Yeah. If anyone out there has access to Westlaw or Lexis and can feed me an account, let me know because I need to be able to like troll basically every opinion written in the history of time too. I can put together a comprehensive note. I don't think ChatGTP has this one. I don't think ChatGTP has this. The parties agree that de minimis test is not right, but they differ in the alternative language they propose. The court thinks that it is enough to say what an employer must show that its burden of granting an accommodation would result in substantially increased costs in relation to the conduct of a particular business. Courts must apply the test to take into account all relevant factors in the case at hand, including particular accommodations at issue and size. The court declines to adopt other elaborations of the applicable standard, either to incorporate the Americans with Disability Act case law or to opine that EEOC's construction of Hardison has been basically correct. A good deal of the guidelines in this authority is sensible and will, in all likelihood, be unaffected by the court's clarifying decision, but not be prudent to ratify in toto a body of interpretation that does not have the benefit of clarification the court adopts today. What is most important is that undue hardship in Title VII means what it says, and the court should resolve the hardship would be substantial in the context of employer business in a common sense manner that would be used to apply such test. Is Kurt okay? Kurt said better. Kurt will press on. We press on. We get better. I need a nap. The court also clarifies several recurring issues. First, as the parties agree, Title VII requires an assessment of possible accommodation effect on the conduct of an employer's business. Impact on coworkers are relevant only to the extent those impacts go on to affect the conduct of other business. A court must analyze whether that further logical step is shown. First, a hardship that is attributable to an employee's animosity to a particular religion, to religion in general, or the very notion of accommodating religious practice cannot be considered undue. Bias or hostility to religious practice cannot supply defense. God damn it, my eyes. Second, Title VII requires an employer reasonably accommodate an employee's practice of religion, not merely that assess the reasonableness of a particular possible accommodation or accommodations. Faced with an accommodation request like the plaintiffs, an employer must do more than concluding that forcing other employees to work overtime would constitute an undue hardship. Consideration of other options would also be necessary. Having clarified the standard, the court leaves the context specific application to the lower courts in the first instance. Justice Alito delivers an opinion for a unanimous Supreme Court. Thus, that brings us to the end of the case of Groff versus DeJoy, the postmaster, in which case we learn that religious accommodations must actually be accommodated and more than just de minimis. So this will put an increased burden on employers to actually, try to accommodate their employees because right now they've not been able to. They've been able to say because no, it would just be, kind of mildly difficult for us, and they have to show something a little bit more because the law requires to show accommodation. So that will have to press on. And as for a moment, that will bring us to the end of discussion of this case. Okay, I am tired. I'm tired. I'm too tired and grumpy. And I need a break. So the last Supreme Court decision will have to remain for another time. So we are now one short. So we will not learn about the Lanham Act today. Stan, thank you for the super chat, which reminds me to check on other super chats that came in. Let me check the YouTube mod chat and see what we go. This is, not on the YouTube mod chat. Okay, it's in my PERT DMs. Maria asked thoughts on Pearson going into day 3 deliberations. No particular thoughts. Jules Buddha showing continuing love to the channel. Thank you for the 20 gift memberships. Angie Torres gave $10, and Alan Parker also gifted 20 memberships. Special shout outs, by the way, to both Jules Buddha and Alan Parker. Both people have been very strong contributors of the channel lately and have really shown a lot of love with the gift memberships, and they are extensively appreciated. Thank you very, very much. I appreciate that. You guys are really, really thoughtful. So thank you, Jules Buddha, and thank you, Alan Parker, for all your continuing love of this channel. Lisa McFadder said $10. Love learning from you. Thank you. Come on now, became an uncivilian. Thank you for hitting that beautiful join button. Lisa McFadder became an uncivilian. Thank you for hitting that beautiful join button. Nijit gifted 20 gift memberships. Thank you very much for all those gift memberships. Donna Parker gifted me a lemon. That looks very happy, gifting me $20. Kizzy said, if you thought about becoming a law professor, yes, if a law school would hire me. I suppose I could sign up with ALS, but that sounds like a being pain in the ass. And those are all the gift memberships that came in today. Thank you for all those gift memberships. That's very nice. Okay. So all that good stuff. So let me see what I need to do here. I need to go to ChatGPT real fast. Yeah, Lord. All right. I will sign off for now. This has been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.